Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Avi. Avi is a real estate and estates lawyer and also a mediator, and looking forward to talking to him about all of those areas. So, first of all, Avi, thanks for joining us, and maybe you could tell us a little bit about yourself, your practice, and how you got into law.
Well, thanks for having me. Great to be here. Just to start by saying that I usually am the host of a podcast, so it's nice to be on this end of the microphone, receiving questions, and have the opportunity to speak a bit about myself and my background. So thank you very much again for having me. I started my career actually working hard in different areas. I remember spending summers even doing telemarketing. I then ended up getting into finance and insurance, which was kind of like a branch of estate planning. That's kind of the way they packaged it, at least. And mind you, it is an important part of estate planning, insurance, and financial planning. So that's how I started my career. But I don't think it was for me. I just kind of landed up doing that. While I enjoyed it and learned a lot, it was a stepping stone to law. I had some experience with a lawyer and thought, I want to be like that. It was a nice experience and to see what they do. And then I went ahead and studied law, got some great experience working also in different, the first few years of practice, you just kind of, as far as I'm concerned, experiment with a few different practice areas. So I tasted a bit of personal injury and employment law, and I went around even with a criminal lawyer for a little bit, and got my main articling experience at a corporate commercial firm. And then I worked as an in-house trustee. So I got a lot of broad experiences for my first, I would say 3 or so years of practice, maybe even more than that, 3 to 5 years. And then after that, you have to narrow it down. You kind of experience enough that you pick an area or two. And that's how I came to estates and real estate, 2 areas I really enjoy. Now, just to explain that there's different aspects to estates and real estate. There's the litigation side, people going to court about the disputes relating to their estates and real estate. I'm on what's called the solicitor side of things. So I try to avoid disputes as much as possible and just focus on closing deals on the real estate side of things, drafting wills, estate planning, trusts on the estate planning side of things. And that's what they call the solicitor side. So that's how my practice has developed. I guess the beauty is you find something that fits your personality. I didn't enjoy the conflict of a litigation practice, so kind of transitioned into the solicitor practice, like I just explained, and enjoy the helping people. If you think estates and real estate, there are 2 areas of law which touches upon almost anyone. At some point in their life, they're going to own real estate, hopefully. And you also need a will. You have a family, you have a business, whatever your circumstance may be, a will is strongly recommended. So it's an area of law that you get to meet a lot of people and help a lot of people.
All right, so let's start with one of those areas. You mentioned estate planning there. What are the types of matters that, someone's coming obviously to get a will drawn up, let's say, or power of attorney. Can you maybe tell us a little bit more? What are the sort of things that you're doing and what goes into it? And I guess related to that, some people might say, hey, I went to Staples or whatever store and they have this will builder kit. Like, what's the difference between coming to you and filling this out and going that route?
Right. So, like I said, starting with the estate side of things, I do non-contentious estate matters. So that includes estate planning, including wills, trusts, powers of attorneys, and also probate. So when someone passes, it's often that they require probate, which is approval from the court to appoint the trustees. There's a process involved in that. So that's other things we do. Typically, people come in and they're concerned about their family. They're concerned about their assets. and they want to be able to document on paper their wishes. And that's really where we come into it. We listen and we understand and we guide to the best possible plan, so to speak, to help the client implement their wishes and ultimately allow their assets to pass over to the next generation or whoever else they want to pass their assets over to. Appoint important people. So there's the power of attorney for property and the power of attorney for personal care. Those are documents that are effective while you're still alive, and they're appointing people to take care of you if you're unable to make decisions regarding your personal care or your property. And they're both very important documents as well. So we go through and help clients understand and appoint the right people to take care of them. And then, branched off from there goes into the will, because once you know who's taking care of you, if you're unable to while you're still alive, usually it helps you understand who's going to be the trustee in your will, for example. And then you go into estate planning when you're no longer around. How do you foresee things happening? So, people, if it's a very simple situation, you asked about the staple wills. If it's a very simple situation, there are options online. And I'm not bashing them completely, because they do fulfill a purpose. If people can't afford perhaps professional estate planning advice, there is a market for it. And it's specifically for if there's very simple circumstances. Now, the caveat there is a lot of people think that their circumstance is simple, and it's really not. But, if everything indeed is simple, then those wills could fulfill a purpose. Now, they have to be executed correctly as well. That's another complication. But, if everything's done right, certain wills that are available online do the trick. If there's any bit of a more complicated situation, I deal with a lot of blended families, second marriages, children from, different marriages. That's quite common. Different assets people want to discuss and plan for. People want to leave different gifts in their wills to different charities or other such people. When you want to, or trusts, you're dealing with a disabled beneficiary or certain trusts you want to establish in your will, it becomes more complex estate planning, in which case those, I guess, over-the-counter solutions, you can call them, just won't cut it. They won't do what you want to do ultimately. So you have to understand what the person wants to do with their estate plan. And, if it could be done over the counter, so be it. But, there are risks involved. Otherwise, you come to a professional. Like anything, you get what you pay for in a way.
Now, what happens if someone doesn't have a will and they pass away and it's dying intestate, I believe? What is that something where someone comes to you and says, "What can I do if, let's say, they're the spouse or the only surviving kin?" What complications arise in situations like that, and what can you do there in terms of assisting someone in sort of dividing up the residue there of what's remaining and so forth?
Yeah, absolutely. So if someone doesn't have a will, like you said, they die intestate, and they, because they don't have a will, the law applies. In Ontario, it's the Succession Law Reform Act, and the law determines what happens with that person's will. So the first share goes to the spouse if they're married, and then the rest is split between their children, one or more, certain amounts that are laid out in the law. And it has to be distributed that way. Now, obvious complications arise if that's not reflected in reality. Like the guy has a different relationship, or the children are not in touch with them and they want to leave it to somebody else. Any sort of reality that's not in line with the law could complicate the estate, really, mess up somebody's wishes and plans, and really force it to get inherited one way according to the law, which is not the person's wishes. So if someone came to me like that and they said someone died without a will, usually we go through whether probate is required. What kind of assets are there? That's generally how you start. You look at the assets and determine, are those assets, do they require probate? And If so, we have to go through the probate application, like I said, apply for a certificate of appointment of estate trustee, in this case without a will, and go that route. If you don't need to go through probate, then you just kind of guide the beneficiaries on how their estate should be distributed according to the laws of intestacy. It gets complicated also because certain assets are held maybe jointly, maybe there's already a beneficiary designation listed. If the beneficiary designation is not according to the law, the beneficiary designation trumps, but all these things could complicate the estate plan. So a will allows, again, the person to put their wishes on paper and kind of synthesize all their different assets and all their obligations and make it into a clear intentions on the paper.
And I guess probably related to that is the biggest problem that you find is that people either think about their wills when it may be too late, right? You mentioned power of attorney. Maybe they're already at a stage where they can't provide proper instructions. So, I mean, is that sort of the message that maybe you want to send out is go and get a will, even if you're like in your 20s or 30s, right? I mean, it doesn't hurt to have one.
Absolutely. It's always good to have a will. It's part of the estate plan. As soon as you have any bit of assets or responsibilities, whether it's money, property, children, family, anything, it's recommended to have a will. And you go through the process with a professional and you really see the value in it at the end, how important that process is. And if circumstances change, you update your will, but it's important that it reflects your current circumstance.
And what about that in terms of, I think it's called the codicil, if I remember back to my studies there, but in terms of making changes or forgetting to make changes, let's say you get divorced and you never update your will, does that kind of still hold weight, or what happens in situations like that?
Yeah, so it depends on the changes. Some minor changes could be effected with the codicil. Certain major changes, they suggest just making a new will altogether. Now, you mentioned something about marriage and divorce. The beginning of this year, January 2022, they changed the law and they made it more accurately reflect current circumstances. So whereas a will would have been revoked, now it's no longer revoked if you married or divorced. So it reflects the current circumstances. Now, people still should keep their documents updated in these circumstances, especially when there's major changes like that, a marriage, a divorce, a separation. Also, a separation is always a tricky one because you're kind of in a limbo position. And if anything happens to you, then, you're still married. So it's going to go to your spouse, but that's kind of one of those things that was updated as well. So we're lucky in a way that the laws have, the estate's laws have at least updated a lot lately. And, the Attorney General in Ontario has been very proactive about that. And, we're thankful as estates lawyers. But now that I'm on that topic, there could still be more to go. And one of those things are digital wills, which are still not allowed in Ontario. They are allowed in BC and other jurisdictions around the world. But there's problems there. There's issues with digital signing because there's a lot that goes into the witnessing of wills. That whole process really confirms and validates that this is the person who's signing it, and the two witnesses being there in person and signing as well. So there's a lot of value to the old school way of doing it. But, we're in a technological world. And if you have the right validations in place, I think that's the direction we're going at some point in the future.
So right now, I'm not sure then as a result of COVID and so forth, but are you allowed to, like, let's say over Zoom, you say, here's your will, I've sent you the file, and they sign it, and it can be digitally witnessed or sorry, electronically witnessed, or how's that? I mean, I know you mentioned you can't do digital wills in Ontario, but what can you do, if anything, electronically now?
It's a bit of an annoying process, and I think it's because we're in limbo. We can sign wills, what's called by counterpart. So if you have a copy of your will with you, and I have an identical copy of your will over here, I bring in a second witness, and we can witness you signing and us signing at the same time. And then your will is only valid when those two copies are put together. Okay, your signed copy and our signed copy as witnesses need to be put together, and then that's one way to do it. So there is a virtual component. We don't have to be sitting in the same room, but like I said, there's more room in the sense that you still can't put a digital signature on it. You still need to sign with wet ink and two copies at that point. There's perhaps more room to go as soon as we can confirm that it's being done right. And there's a lot that goes into the digital signing. It's not just putting on any electronic signature. There needs to be some, identity verification involved. With that, I think it's a good option to proceed. Like there's more to do. With my estate planning, I record the call. I go on a Zoom call like this, record the call, obviously with the client's permission, and the recording becomes part of the file. So, whereas before a lawyer used to write notes and have those written notes, which sometimes are illegible, be part of the file. Now you can get what the person's actually saying as part of the file. Hear it from their mouth as, directly. And, I think that holds more weight if it lands up going to court for whatever reason. And that's one of the ways technology has helped in the estate planning world. Technology has helped in many ways as well, but again, there's still limitations on how the documents can be executed.
And I mean, is that then like with the digital signature, you think that the concern there, well, do you know exactly how it was signed? It could have been somebody else. I mean, the same sort of concerns with DocuSign and all those related programs, right? But is that still kind of the direction you'd like to see go in, or are you more of a fan of just keeping it, come into the office and let's put pen to paper and whether it's written notes or typed notes, maybe that there's a record of that, or do you prefer? I mean, you mentioned like having the Zoom calls recorded. I mean, is that a better receipt, let's say, of the conversation and the knowledge on the part of the person for their will?
I think so. I think the video record is as powerful as it gets. And so much so that even if the client comes in person, which I do in person meetings as well, still with the client's permission, I sometimes record the call. I find that helpful and the client finds it helpful. So that's one aspect of technology. There's a lot of benefit in the old school way of signing wills, having two witnesses come and confirm this person signed the document in their presence. And I think it's that safeguards the identity of the person, and this is the document that they're signing. It really validates that. And digital signatures have some aspect of verification. People hold up their ID to the camera, for example, on real estate signings and commissioning documents. You're allowed to do it completely virtually, so it's a lot easier to do. But because a will is such a powerful document, so impactful, that could really, it's a person's life that's culminating in this document. There needs to be a lot of verification there. So like I said, I think the world is going in a way that people are going to be able to sign digitally, put their signature on the document, and there'll be other, safeguards and verifications involved in that process. So eventually, I think that'll happen. Now, I don't know when. I don't think it's going to happen this year, maybe, but in the next decade or so, it's probably going to happen.
Now, you touched on litigation and estate litigation, where sometimes there's parties that dispute maybe the authenticity of the will or the wishes or anything like that. Maybe you can kind of give us a primer there. What are some of the issues that come up in estate litigation and how that process works out?
Yeah, it's a horrible process, and that's why I don't like to get involved in it. And it's because it's families fighting. It's a lot of emotion involved, a lot of childhood trauma, perhaps, a lot of money involved. Parents with properties, and just dealing literally with family fights. And anything could come up. So you're making a new will, and it's leaving the estate either equally or unequally. Either way, one sibling will be unhappy with it. I spend more time with mom, I need more. You didn't spend enough, you shouldn't be getting as much. Either way, there's all sorts of reasons why people fight, whether you cut it this way or that way. And there's a huge industry about estate litigation. It's a lot. I have a lot of friends in that area of law. If people come to me with an estate issue, I can direct them to the appropriate people. But I just don't enjoy personally. I made the personal choice that I don't like spending my day on sibling fights, and that's really, if anything, I want to spend it on resolving sibling fights. We touched upon the mediation there. That's something I would be happy doing. But a lot of times people are just fighting, and they're, some like family law clients as well. They're irrational. Like they just want to fight for emotional reasons. And, there's a place for that in the legal system, because they may very well have a valid claim. It's just, whatever their claim may be, usually it surrounds the will, the capacity of the person when they're drafting the will, the circumstances surrounding all that. Any number of reasons. There's a whole list of grounds that people could challenge a will under. I think I heard 16 or more. So there could be any number of reasons that a will gets to litigation.
Okay, so let's switch gears here, because I know you have half of your practice in another area. So certainly the housing market is going up and up and up and up, and I would assume that also translates for more work there on the real estate side. So what goes into your real estate practice? What are the types of things you do there with regards to real estate?
Yeah, so like I said, it touches upon like the average person. So people buying from their first home to real estate investors with multiple homes. And we deal mostly with the closings. So people come to us, they already have an agreement of purchase and sale, and they bring it to us as a lawyer to close the transaction. Sometimes we help them even from preparing the agreement of purchase and sale, and then help them all the way through closing. Usually what goes along in a real estate transaction is, from a lawyer's point of view, at least, you search title, which means you're checking what you're buying, exactly what your client as the purchaser is buying. If you're the seller, you receive a requisition letter to remove things from title. Some of those things could be a mortgage. So mortgage has to be dealt with also from the buyer's or the seller's point of view. We deal with a lot of mortgages, even outside of the buying and selling process. If people just want to refinance their home, they have a house and they need to do a financial refinance, so we can help them with that. And there's so much in real estate that is just touches on the everyday life. And I'll just give you one example of how estates and real estate also intersect. Is, real estate is usually the main asset that people have. And a big discussion in the estate planning process is what they want to have happen to that house, their main asset. Now, if it's held jointly as joint tenants, there's an automatic right. It's called the right of survivorship, where it passes to the other joint tenant. Now, you could imagine from an estate planning point of view, that's very effective, because you can automatically transfer ownership from one owner to the other. It's common with spouses, for example, but it could be with others as well. If you don't hold the property jointly and you hold it as tenants in common, for example, then it goes according to a will, and there's probate involved. So having these discussions with clients when they're owning property, it's important to understand also, what they want to do with this property as from the estate planning point of view. That's how interconnected they are, and how you hold title has implications in your estate, in your estate plan. So, when people are buying property now, they have this big asset, they should also consider having a will, because like I described, it goes together.
Okay, so let's walk through then. Maybe, as you said, someone gets an agreement of purchase and sale. Let's say from the buyer's side, and they come to you and say, okay, well, they've agreed, we've agreed. closing is in 60 days or something, and what goes on in terms of the work that you're going to be doing for them?
Okay, so you review that agreement of purchase and sale. You see if there's any conditions that need to be met. Set up any dates that are listed there. And then you have to, like I said, search title, making sure what your client, the purchaser, is buying is clean of any mortgages, liens, issues on title. If there are any issues, call them on title. You write to the seller's lawyer, and it's called a requisition letter, and you requisition, delete these things from title in order to close the transaction. Usually the requisition date is listed in the agreement of purchase and sale, and you have to send it by that date. Okay. Then you get the response from the seller's lawyer along with the numbers, how much you need to send them on closing. It's usually the sale price. And then there's adjustments. Adjustments are for example, the property tax is adjusted. And if it's a condominium, you have the condominium common expenses that are adjusted. So you get a number that's pretty close to the sale price, but not exactly, minus the deposit, of course. So you get the final numbers together. On behalf of your client, the purchaser, you have to buy title insurance as well. That's a standard insurance that goes along with purchases. And then if they're getting a mortgage, you have to get mortgage instructions and carry out those mortgage instructions. Then once you have all those ducks in order, then you have a signing meeting with your client, the purchaser, and you have all their documents ready for them. And at that meeting, you let them know the final number they need to send you for closing. So if the closing price, the sale price is $1 million, and your mortgage is 800 grand, they need to send you 200,000 to close the transaction, the balance. So it's a whole list of documents you send them, including the final number, my trust account details, and then we meet on a Zoom call, kind of like this, to sign the documents. So I go through, share my screen, sign the documents with the client, usually electronically. So either the client could print the documents and sign their wet ink signature on the documents if they want to, or I can just let them put their signature on it electronically, and I witness them doing that. So it's a lot easier to sign documents in a real estate transaction, right? They just send them back to me. I have them. There you go. As far as that's really the extent of the paperwork. Then closing day comes along, and on closing day, I get the mortgage funds, the 800 grand in our example, and the balance from the purchaser. You send it to me in my account, and I have the full funds. Once I have the full funds, I wire it to the seller's lawyer, the full amount that he told me. Once he receives the money, he lets me know, and then he what's called releases the transfer, and allows me to register the property. So there's a bit of a process that goes into it. Kind of what I tell clients is, as long as you have the money, the mortgage funds and the balance of the funds, as long as you get those to me, we should be okay with closing. Obviously issues could come up. There's a long list of issues that could come up in a real estate transaction. I pride myself on closing the deal, resolving the issues, and that's really the point of it all, closing the transaction. If it gets contentious, if an issue arises, usually it gets referred on to litigation if that's what the clients want to do. But again, my job is to avoid all that and close the deal.
So is that all happening on the closing date, right? I mean, is there that usually typically like when would that be, or when would all that be happening? I know you also had a post a couple of days ago there about when do I get my keys, right? It's probably the first question the buyers are asking is, when is all of this done? I get the keys, I can bring in the U-Haul truck and settle into my new home. So how exactly that all happens that you mentioned there,
right,
in terms of a time frame?
Good question. The keys are always the first thing that people ask about, but they're the last thing that happens. So in my brief description over there, once we register the transfer, which means we register that you're the new owner of the property. Congratulations, you're the new owner. Then I send that document to the sellers, and then technically they release the keys to us. Now, like I said in the post, it's usually left at a lockbox. So a buyer can just go and open up the lockbox, get the key inside, and go get it whenever they want. But the keys happen right at the end. So people often try to move on closing day, and they have all their stuff at a truck, and the truck's waiting outside the new property. And unfortunately, we haven't closed the deal yet. There's some delay in funding, or any number of reasons. It's a little bit delayed until up to 5 or 6 p.m. And you don't want to be stuck there paying your movers by the hour, and you're not allowed in the property yet, because you're not allowed in until all the funds are received and we transfer ownership. So I try to tell clients, if you can, don't move on closing day, or at least plan for it to be the end of the day, if anything. And we try to close again as soon as possible. Usually it's before noon even, but just to give the client that buffer. Anything could happen and things could be delayed. So you may only get your keys later in the day.
And I guess on that, everyone's always anxious to get in. What if they move in and there's they discover I don't know, like something that was a fixture that was supposed to be included has been removed, or things along those natures, right? Maybe that aren't such big that they're not going to throw apart the entire transaction. But is that sort of the deadline they have to kind of make note of it, or can they bring up something the next day or the next week or whatever?
So yeah, you never want that to happen, because once you're the owner, and there's very little recourse against the seller after closing. There are some exceptions to that, but you want to do an inspection, a final inspection, maybe a day or two before closing, to avoid that from happening. Now, if it does happen, you could obviously go ahead, if it's a minor thing, and try get it back from the seller. And if it's a major thing, go through litigation. But again, after the transaction, if it gets there, you want to resolve it quickly. If not, it's unfortunate. I see sometimes things get dragged on and it goes to litigation, and people are stubborn, and for whatever reason, things linger on. But you want to avoid all that as much as possible. Try to deal with those issues if you see a fixture or something, before closing if possible. And you could always adjust afterwards if the parties are nice.
Now, with the market being as it is, sometimes buyers are waiving a bunch of these conditions. And you mentioned condos, like maybe the status certificates or whatever. And then later on, they discover some kind of problem before closing. Are they kind of out of options if they've waived a lot of that ahead of time? And then they're like, oh, wait, what can they do anything? Or are they kind of got to go through with the transaction?
Yeah. So, what happened with the client one recently is they waived the inspection on a property, and then after closing, they discovered issues with the foundation or the mold or something, which is quite serious. And you would have discovered that with an inspection, but like you said, because of the market, they waived that inspection, which is quite a basic clause. Like you said, the review of the status certificate, it's quite a basic clause. But in this hot market we're in, buyers are putting in clean offers without any conditions. And if they want to take that business risk, I guess they have to, deal with the consequences. And it's unfortunate because, they go ahead with the transaction and they discover these things afterwards. And then in a certain sense, they're out of luck because that's the agreement that they entered into. There are certain circumstances where title insurance will cover title defects or certain issues, but generally people have freedom of contract. And if they choose to enter into agreement without any conditions, it's their right to do so, and they have to deal with the consequences.
And related to that is sometimes when you're putting in offers, well over asking and maybe well over the value, and then how the bank might come in and appraise it and say, well, you know what, we're going to give you a mortgage of, I think the example we were talking about, 800,000, but we don't think that's $1 million house. We're not going to give you that. And then the buyer's like, we don't have that 50,000 more now to put as a down payment. What happens in a case like that? There's like, I mean, obviously if the transaction falls apart, what happens to the buyers and with respect to maybe their deposit and everything along those lines?
Those are all issues and fact specific. And if there's a good lawyer involved on both sides, usually there's a resolution one way or the other. But I mean, black and white, yeah, the deposit is at risk. The deal's at risk. There's certain litigation that they're exposed to, the buyer, if they can't close. These days, when the market goes up, there's not much damage there because the sellers could just get even more. But if for whatever reason there's it's called transaction contingent on that one, and there's damages which flow from that transaction not closing, and there could be issues involved. Now, again, a good lawyer could smooth things over and resolve things. You could try to do that, but anytime you're in breach of a contract, there's liability involved. Litigation lawyers should be consulted, and it could be a big issue depending on the circumstance.
And then what about on the other end? I guess the same kind of question. Let's say there's a little dip at the time you accept this offer, and then turns out your neighbors are selling their property like 2 weeks later, and they're getting 50,000 more or 80,000 more, and you're saying, well, can I just cancel this agreement here and just relist it and get $100,000 more, and maybe just lose the deposit? Like, what happens on the seller's end if they don't want to go through with a transaction?
I wouldn't advise them to cancel a transaction. Maybe another lawyer could help them through that process, but I'm of the, I guess, school of thought that they entered into this agreement. They have to go through with the transaction. If they come to me as their lawyer, I'll say, I'm here to close the deal. It's your fault you entered into an agreement that you think is too low. Those are, again, the consequences of the free market, their choice. And, as far as I'm concerned, we close the deal, even though you think it's too low. It becomes litigious if they want to get out of it in one way or the other. There's schools of thought about what to do with the deposit. It's not so simple that it gets lost. It needs to be released. It's not such a simple thing which people just could make these unilateral decisions. I think people could do whatever they want at the end of the day, but I just think there's consequences.
Now, on that, I mean, another area you mentioned that you're getting into there is mediation, and I know there's a lot of different types of disputes. Is there anything kind of in particular that you're looking to do more mediation for in terms of areas? I mean, of either your practice or completely different areas, and kind of what drew you into looking into mediation as something to sort of supplement both your real estate and estates practice?
Yeah, so I want to do mediation for estates and real estate matters first and foremost. You find areas of law that just fit your personality, and I think mediation is one of those for me. Just helping people, doing something that I enjoy, relatively short-lived. You don't have to have these drawn out relationships with clients like in litigation for sometimes years on end. Mediation is a matter of a day. You're there to help people resolve a dispute and then kind of move on. So I think it fits my personality and I enjoy it. But in a way, it's one of those, fake it till you make it type things, because I'm just getting started with it. It's one of those things you have to build slow and steady. And even so, it's hard to make a living just off mediation. Very few people do, but it's a nice service to offer. And, if you can help people resolve their disputes, I really think that's what it's about.
And I guess in terms of everything there, the other thing that you do is you brought up there, you have your own podcast. I think you had Marie Hennon not too long ago there. So maybe tell us how that came about and what are the types of things you do for your podcast?
Yeah, so I have fun with it. like I'm a relatively junior lawyer. I'm still in my first decade of practice, and there's a lot to learn. And I just took the opportunity. I started it during COVID, mid 2020, and I just thought, let's learn from these great lawyers. So I speak to only the best, I would say, people that I can really learn from and grow from, and talk about high level issues with. And really, it's things that I'm interested in and I can learn from. And it's been received very well, the podcast, and it's just something that I enjoy. And if I find someone interesting that I can talk to and learn from and have an interesting discussion with, I go for it. And everyone else, the audience, enjoys it as well, as I'm sure you could appreciate. And it's been great, residual benefits from it as well. Learning and connecting with really amazing people. I'm so grateful for really the opportunity to speak to these people and connect to them, and have them in my circle, so to speak. So really, it's done wonders for me. And it was just an idea. Just started it because it's relatively easy to do. You just get a camera and a microphone and start talking to people, and it's been wonderful. So congratulations to you two on your podcast, and we should both keep it up.
Yeah, I mean, everyone always asks the same thing there, right? Is that you have the camera, you have the microphone, you have, I mean, you don't even necessarily need that, but you just get a Zoom link or something, and away you go, right? So
Right.
pretty easy to do. Especially we were talking about with wills and estates and real estate and doing things over Zoom and virtually. I mean, such a benefit that we've not tapped into as much until the pandemic kind of forced a lot of these changes. And in a profession that's traditionally slow to respond, I think now that we've embraced it over the last couple of years, it's going to be hard to kind of go back to some of the the traditional means of doing things. But certainly podcasting here, there's a big benefit that's come out of the pandemic. Now, one of the things I do talk about quite a bit with the people that I've interviewed is, we're in a profession, it's a lot of, you're talking about closings happening all the time. Estate people need to get their wills in at a certain time. Now, how do you kind of take care of all of those demands of your clients, and then as well find time to just take care of everything on your own end, right? I mean, in terms of your own mental health, and find the time to do things like your podcast, or to take up mediation or anything like that. What sort of you can share with anyone listening about kind of finding that balance?
Yeah. It's hard. There's no balance. There's no simple answer to it. I say I'm a full-time dad. I'm a full-time lawyer. Just everything is full-time. You do as much as you can in the amount of time that you have. You've got to be committed to everything. Sometimes, more focused on work, and there's more time available to invest in work, and sometimes more on family, and you've got to just really enjoy both of them. I don't know if I'm the best person to ask about that. I guess simply you work when you can, and I'm like work random hours. So because I'm on my own and I don't have, I guess, a law firm, I can do the work when I want to do it. And sometimes that's late at night or early in the morning. And, the flexibility of being able to do that, just you get it done whenever you can. I'm also, like I said, the first decade of my practice. So I don't think I should have as much of a work-life balance, as maybe later in my practice. There must be a certain time where you do invest in growth and working and everything. And, again, it changes, it ebbs and flows. So I think as long as you're first of all doing your best, but also focusing on growth and improving yourself and your practice, that's as best as you can do.
Perfect. So, Avi, thanks so much for taking the time and joining us here today and sharing about your practice and the areas of estates and real estate there in particular, as well as mediation and your podcast. So, wondering if you have any final words of wisdom for any of the students or young junior lawyers or paralegals or anyone listening about any of those areas, and any advice you can offer for them as they look into, when you're saying, look, I'm only in my first decade of practice. I mean, a lot of them are just starting or haven't even started yet. They may be in school thinking about careers in real estate or estates, or even for my law clerk students to be law clerks in those fields. So anything you could share. And thanks once again for joining us today.
You're welcome. Thank you for having me. I really think, at least how it worked for me, is that any bit of experience will help in whatever you're going to do in the end. So get some experience one way or the other. And, you talk about estate planning or real estate. There's so many ancillary services around those two areas. So I'm now a lawyer practicing those areas, but I didn't start as a lawyer. So any bit of experience you can get, I think, will be helpful to your practice in the long run. It's a journey. Take your time, get any bit of experience, and learn and grow along the way. That's my 2 cents.
Perfect. So thanks again for joining us. All the best. Take care, everyone.
Thank you.